there's enough evidence in the police report to find that he committed the offense. But this police report raises a lot of questions for the court that nobody thought to investigate to have answer. 2024 CR 012860, State versus Robert Alamon. Can I have parties announced?
Andrew Garcia, United States.
Roberto Ambrosino for the defense.
Are you Mr. Alamon?
Yes, yes.
Counsel, have you received all discovery and did you review that with your client?
I have.
The court will find that the state is in compliance with discovery. Mr. Alamon, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, sir.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, sir.
Counsel, do you waive the reading of the indictment?
I do.
State, are you proceeding on the indictment as presented?
No, Judge. Waiving count one, proceeding on count two.
No objection.
Mr. Alamon, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, sir.
Did you understand in count two, you're charged with unauthorized use of a vehicle that's a state jail felony? Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine.
Yes, sir.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. Did you understand by entering this plea you were giving up those rights?
Yes, sir.
And did you intend to give up those rights and enter into a plea in this case?
Yes, sir.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, sir.
Off the record for a moment. Norma, have Ross Rodriguez to come in, please.
Yes, ma'am.
We're back on the record. Counsel, has your client been able to provide you with any defenses?
Yes.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Alamon, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Judge.
Anyone promised you anything other than the plea?
No, Judge.
Are you satisfied with the way you've been represented?
Yes, sir.
Are you a U.S. citizen?
Yes, sir.
The court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the plea, the state recommends deferred adjudication, and there's to be restitution of $765 to the complainant. Did you understand that to be the plea?
Yes, Judge.
Defense is at the plea?
It is, Your Honor.
State is at the plea?
Yes, sir.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Judge.
Counsel, are there any such motions?
There have none.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years and there be no contact with the complainant. Did you understand that those were recommendations from the state and the court does not have to follow those recommendations?
Yes, Judge.
Then to the offense as charged in count 2, how do you plea?
No contest.
State, any evidence?
State Office Exhibit 1 and attachments, sir.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Judge.
Again, did you understand you have a right to jury trial?
Right from the start, this case feels unusual. The judge admits there's enough evidence for guilt, yet something about the police report doesn't sit right. That's the moment you know this hearing might not follow the usual script. So the real question is, what exactly did the report miss, and more importantly, why did nobody look deeper?
A right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent.
Yes, Judge.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Judge.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. My client is very young. He made an unfortunate decision, but I think he realizes the gravity of his mistakes, and he'll do well going forward. He is working on obtaining his high school diploma. He did not finish. I don't believe he has any felony criminal history. I believe he has a couple months to do it. So I'd ask the court to follow through with that.
All right, how old are you?
I'm 20, man.
All right, why have you not graduated from high school?
I'm working on getting my my high school diploma. I'm doing a little program. I'm about to start in like a week or two when I get my ID.
No, I understand.
I dropped out.
Why?
Just a lot of family problems and stuff.
What type of problems?
Just my dad's been sick, his kidneys been failing and all that. Just a lot of, you know what I'm saying? I have to take care of my baby sister. I have to take care of my baby sister, man. And my dad's he's sick right now in the hospital.
All right, so who else is there for your father?
I don't know. Nobody. Just us three.
All right, where's your mom?
I don't know.
All right, has Child Protective Services ever been involved in your life?
Yeah, when I was younger. But my dad always got us in custody and everything, took care of us.
All right. So, do you have employment or no?
No, I'm not employing. I'm getting my ID in a week. Because as soon as I was in county for about 4.5 months, and I was a trustee, and I was working, getting my GED and all that.
All right, and how old is your sister?
My sister, she's 15.
Right. And so, is everything he's telling me true?
He was in county for a significant amount of time. I was able to get him out at the 90-day mark, and then I think he did not get out because he had a pre-existing warrant, misdemeanor case. So he was in county for.
And what's the misdemeanor case?
I wasn't on that case. I'm not sure.
Yeah, I got it dismissed.
What
I
was
got
that?
one time served. Assault bodily injury.
Against?
Who
Who was that against?
I forgot who my lawyer was. I don't know because they kept.
No. Who was the complainant in the assault case?
Oh, I don't know. Man.
What are you saying?
Oh, it was just somebody downtown random.
We didn't really discuss that.
Yeah, I got it dismissed.
Oh, it was dismissed.
Yeah, I only got one charge time served.
And what was that?
I think it's interfering with public duties.
Okay. All right, let's go off the record for a moment.
Yeah.
Well, here's the problem with that. That was the time for him to consider that when he committed the offense. This police report, now mind you, I'm saying that there's enough evidence in the police report to find that he committed the offense.
Let's pause here for a second because this part is important. The defendant is entering something called deferred adjudication. In simple terms, the judge is saying I'm not going to find you guilty today, but if you mess up during probation, I absolutely can. It's basically a second chance, but with a very tight leash.
But this police report raises a lot of questions for the court that nobody thought to investigate to have answer. Thank you, State. You may be excused. All right. This is what the court is going to do. The court is going to defer finding of guilt. The court will sentence you to 2 years deferred adjudication. There's to be regular reporting by Zoom or in person. Do you have employment?
No, not yet, man. I'm waiting to get my ID. I have my ID from in a week.
All right.
As soon as I got out, after I did my timeline, I had to set up an appointment. My appointment is on May 20th.
All right. There's to be proof of employment within 45 days. No employment as a home health care provider or with minors. There's going to be 100 hours of community service restitution. That will be waived if he obtains his GED or if he completes some sort of trade school. There's to be restitution of $765 to Stephanie Regalado. And there's to be no contact with Stephanie Regalado. There's to be random UAs, field visits one time per month until further notice. There's to be no contact with Jorge Holguin, Holguin. Assuming the co-defendant or the other person in this is Jorge Holguin.
He is not the person.
Well, we'll see if the mother wants his case dismissed or not. All right. Probation, is there anything else? Okay. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
In this court to be we can go off the record. In this court to be successful on probation, communication is key. And as a 20-year-old who does not have your high school diploma yet, you got a lot on your shoulders. You have your sister on your shoulders. You have your father on your shoulder. Here's the thing. You can't get involved with people like this anymore, because if something were to happen to you and something were to happen to your father, then your younger sister, she's just going to get caught up in the system. You understand?
Yes, I appreciate it.
So if there's something you need.
Now the tone of the hearing changes completely. This isn't just about a stolen vehicle anymore. It's about a 20-year-old carrying adult responsibilities, a sick father, a missing mother, a younger sister. Depending on him, situations like this are exactly where courts struggle. Where does accountability end and compassion begin?
Let probation know. If you feel they're not addressing it, you can always come back to court, okay?
Yes.
All right, good luck to you. Is calling 2025 PF 03974. 2025 PF 03973, 2025 PF 03972, 2025 PF 03971, 2025 PF 03970, 2025 PF 03969, State versus Valerie Campion. Can I have parties announced?
Mayor Salem with mistake.
Matthew Allen for Miss Campion.
And are you Miss Campion?
Yes, ma'am.
All right, in each of these cause numbers, the defense has filed a motion for a PR bond. State, have you had a chance to review the motions?
I've not reviewed the motions. I've reviewed the cases, specifically the pre-filed cases.
All right.
As I understand it, that was what now thought reduction of bond for. Since
He's asking for a PR bond.
since the indicted cases are indicted, 17.151 is inapplicable for those. And in addition, as far as I can tell, Ms. Campion did make bond on those cases, and bonds have not been revoked subsequent to careers. But please correct me if I'm wrong.
All right, so here's my question. He's asking for a PR bond in those cause numbers that I've called out. Are you in agreement to the PR bond? Or are you citing another rule that says she's not entitled to a PR bond even though the cases have not been indicted?
She's not entitled to a PR bond because 17.151 gives the courts.
I know, to reduce bond or a bond she can make, or either a PR bond, but my question is, are you in agreement with the defense for her to have a PR bond?
No.
All right, so the answer to that is no. So do you want to present any evidence? Well, before you present your evidence, you are in agreement that she has not been indicted within the 90 days.
Correct.
All right. You want to present your evidence?
Yes, Judge. I would call Miss Campion for the purpose of the bond reduction / PR bond.
All right, could you raise your right hand for me? Do you solemnly swear affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Valerie Kumpian.
All right, state, you may proceed.
Oh, if the defense, I called.
I'm sorry.
That's okay.
That's
I just wanna make
okay.
sure.
I'm used to you being,
I know.
I remember when you were on the other side, but go ahead.
Okay. So the, Ms. Compion, you're the defendant in the cause numbers that were listed, right?
Yes.
Okay. Tell me about, when did you move to San Antonio?
When I was 7,
All right. How old are you now?
35.
And have you lived in San Antonio that entire time?
Yes.
What family and friends do you have in San Antonio?
My mom and my stepfather. I have a 15-year-old son. I have 6 sisters, 3 brothers. My dad, my stepmom, and my 2 little brothers on my dad's side.
Okay, so you have very strong ties. And you would, if and when you bond out, you'd be living in San Antonio?
Yes.
Okay. You've been in continuous custody on those cases.
Emphasis the moment that makes the judge pause, not remembering details about a prior assault case. That's a red flag in court. Judges listen very carefully to answers like this because sometimes what a defendant can't explain says more than what they can.
For 90 plus days, is that right?
Yes, sir.
Obviously, you haven't been able to make any money during that time.
No, sir.
How much money do you personally have either saved up or able to get through assets, selling assets, financing assets? How much total do you have to be able to put towards all the bonds for not just these cases, but your indicted cases?
I have $2,000.
$2,000. Okay. And again, that includes all of any assets that you have a part of and things like that. Okay. You've spoken to your family since you've been in custody.
Yes, sir.
And how much money, same question, through assets and everything combined, do they have to be able?
$1,000.
Okay. And so total, you have $3,000. On your indicted cases, the bonds total about, I believe, $35,000. Is that right? Okay. Has your family contacted bond companies?
Multiple.
Okay, and they have not been able to bond you out on these cases?
Correct.
All right. If you were released, would you remain living in San Antonio? Would you follow every condition of bond that the court put in front of you?
Yes, sir.
Do you believe that, and you said you have a child, do you believe that you'd be able to be employed once you got out?
Yes, sir.
Okay. Do you have a job waiting, or you think you'd be able to get a job?
Well, I had a job before, so I don't know if I still am employed, but being that I haven't been convicted of anything else, I believe they'll allow me to come back to work.
Okay, but even if you don't get that job, you believe you'd be able to stay
Yes.
employed? All right. Okay, I'll pass the witness.
Any questions?
From the stage.
All right. This is what the court's going to do in each of those cause numbers. The court is setting the bond at $3,000. There's going to be partial GPS for employment, waived GPS fees, and there should be no unsupervised contact with minors. And there's to be regular UAs. All right. Now, with regards to the other cases that have been indicted, counsel, where are you on discovery?
Judge, I believe I have received the discovery in those cases. I just have not had an opportunity to review all of it.
All right, Ms. Ferguson, recall this. I need a 30-day reset. All right, we're going to come back on June 10th. State at that time you'll need to be prepared to tender an offer.
Yes, Judge.
Thank you, Your Honor.
Thank you.